From today on, make the rest of your life the best of your life. According to the Fair Credit Reporting Act, FCRA, which is a federal law, the collecting of credit information from consumers and access to their credit reports are both subject to various regulations. This law was enacted in 1970 with the purpose of ensuring that the personal information that is stored in the files of credit reporting agencies, FCRAs, is treated fairly, accurately, and with the utmost confidentiality. The Fair Credit Reporting Act is the primary federal law that oversees the collection and reporting of credit information about consumers. This law was passed in order to protect consumers' rights, the method by which a customer's credit information is received, the length of time it is stored, and the manner in which it is shared with others, including the consumer themselves, are all governed by its standards. The Federal Trade Commission, FTC, and the Consumer Financial Protection Bureau, CFPB, are the two federal agencies that are tasked with the responsibility of monitoring and implementing the requirements of the law. Moreover, a great number of states have their very own regulations that pertain to credit reporting. Title 15, Section 1681 of the United States Code contains the FCRA in its entirety. Please refer to this section. Each of the three major credit reporting bureaus, Equifax, Experian, and TransUnion, along with a number of other, more specialized businesses, are responsible for collecting and selling information regarding the financial history of individuals. In addition, the information contained in their reports is utilized in the computation of customers' credit scores. These scores can have an impact on a variety of factors, including the interest rate that they will be required to pay in order to borrow money, or whether or not they are eligible for a loan at all. The year that the United States Congress approved Public Law No. 91-508, often known as the Fair Credit Reporting Act, FCRA, with the intention of ensuring that the personal information that is gathered in credit reports is accurate, fair, and protected from unauthorized disclosure. Since then, it has undergone a number of revisions throughout the years that have passed. How the law governs the actions that credit bureaus can and cannot take. The Fair Credit Reporting Act outlines the types of information that credit agencies are permitted to gather and provide to their customers. That includes the individual's history of paying their bills, their previous loans, and their present debts. Additionally, it may include information regarding employment, current and former homes, whether or not the individual has ever filed for bankruptcy or owed child support, as well as any arrest record related to the individual. The Fair Credit Reporting Act, FCRA, also places restrictions on who can view a credit report and under what conditions. For instance, when a person applies for a mortgage, a car loan, or any other kind of credit, the lender might ask for a report. In the process of applying for a policy, insurance companies may also look into the credit reports of potential customers. It is possible for the government to request it in response to a court order or a subpoena issued by a federal grand jury, or if the individual is applying for specific sorts of licenses that are made available by the government. Before a consumer's credit report can be released by a credit agency, the consumer must have either initiated a transaction or granted written consent in certain circumstances, but this is not always the case. For instance, employers have the right to seek a credit report from a job candidate. However, they must first obtain the applicant's permission to do so. You should be aware, however, that certain prospective lenders and insurers have the ability to examine certain sections of your credit report without your permission in order to determine whether or not to send you unsolicited offers for credit or insurance. This procedure is known as prescreening, and the legislation gives you the option to opt out of participating in it. In accordance with the Fair Credit Reporting Act, FCRA, a company is required to provide an explanation for the reason that they are obtaining a credit report on an individual. As an illustration, the reason might be in connection with a request for a loan, for the aim of searching for work, or as a component of a credit check conducted by a landlord. The FCRA protects the rights of consumers. An additional right that consumers have is the ability to view their own credit reports. Every year, they are legally entitled to receive at least one free credit report from each of the three major bureaus. This right is guaranteed by law. They are able to make a request for their reports through the official website that is authorized by the government for this reason. Moreover, consumers have the right to the following under the FCRA. In situations where it is necessary for job considerations, determine whether or not their report is accurate. You will be notified if the information included in their file has been utilized against them in the process of applying for credit or in any other transactions. File a dispute with the Bureau and request that they change any information in their report that is either wrong or incomplete. In the majority of circumstances, unfavorable information that is out of current should be removed after 7 years or 10 years in the case of certain bankruptcies. You have the option of filing a complaint with the Consumer Financial Protection Bureau, CFPB. If the Credit Bureau does not reply to your request in a way that is satisfactory, it is expected that certain negative information will be removed from your credit reports automatically after the appropriate amount of time has passed, usually within 7 or 10 years. To the extent that this does not occur, you have the legal right to have it erased. This is an example of how the FCRA works. Take, for example, a situation in which a person is interested in renting an apartment, but the landlord rejects their application, citing the reason as being due to the applicant's credit report or credit score. This is a falsehood, according to the prospective renter, who hypothesizes that the reason for the denial of the lease is due to the possible tenant's skin color or religion, both of which are illegal grounds for such a decision. They are able to get their credit report and examine to see if the information contained in it is consistent with the assertions made by the landlord under the Fair Credit Reporting Act. Additionally, they are able to determine whether the landlord actually pulled their credit history or whether they pretended to do so. If a breach did take place, the landlord might be subject to a fine. What are the requirements for the release of your report? According to the Fair Credit Reporting Act, FCRA, lenders, insurers, landlords, employers, and anybody else who is interested in obtaining a person's credit report are required by the Fair Credit Reporting Act, FCRA, to have a reason that is legally permitted for doing so. To what extent does the failure to comply with the FCRA result in penalties? A fine of between $100 and $1,000 may be imposed for each infraction. It is possible that, in addition to legal fees, real and punitive penalties will be imposed in the event that damages are sustained. In the event that an individual knowingly and willingly gets information from a consumer reporting agency under false pretenses, these individuals may be subject to criminal penalties. What obligations does the Fair Credit Reporting Act place on employers? A person's credit report may be requested by an employer or potential employer for the sole purpose of obtaining information for internal purposes. It is necessary for the individual to have given their agreement to such a request, and the employer must make it clear that the information is being retrieved only for the purpose of employment. Who is responsible for enforcing the FCRA? The Federal Trade Commission, FTC, and the Consumer Financial Protection Bureau, CFPB, are the agencies that are responsible for enforcing the Fair Credit Reporting Act, FCRA, which is a federal statute. A law known as the Fair Credit Reporting Act, FCRA, dictates what credit bureaus are permitted to do and are not permitted to do with the information that they gather about you. In addition to this, it grants you specific rights as a consumer. Due to the fact that the information contained in your credit reports is significant in a variety of ways, it is advisable to check them on a regular basis for any errors. If you find any, you can then request that the bureaus repair them. You are entitled to free copies of your credit reports at least once a year, as stipulated by the Fair Credit Reporting Act, FCRA. This finishes today's video. Comment down below about any opinions that you want to share. If you're interested in watching more videos like this, then do subscribe to us. Thanks for watching. I'm giving you some news you can use.